true that the topic of debt collection is one that is broad, because normally when one takes debts, there is no anticipation that they are likely to default. People don't take debts to default on those debts. Because of human, conditions and circumstances that cannot be avoided, more often than not, people default on debts. Now, the law is very robust on what are the limits of the person giving you the debt, and what are the limits of the person to whom the debt is being given. Basically, the creditor and the debtor. And what the law has tried to do, for a larger extent, because there was a realization in 2021 that the entire Kenyan legal framework is more leaning to the creditor, the one who is giving the debt, and that does not protect the debtor. That is why you would find many times people would be unjustifiably arrested for debts. The criminal justice system would be used to enforce the issues of civil debt. And that is why now today there is a very clear separation on what is available to the debtor and what is available to the creditor. Now, to the creditor, the most important of them all, of what is available to them, is have they been able to fully disclose the terms of this loan when they are giving out the loan? What are the penalties that accrue when, in case you default on this loan? What are the timelines upon which you are supposed to be notified whenever there is default? And then, are they using justifiable means of collection? Because there are unjustifiable means of collections that are completely outside the law. So that is what the law tries to do with the creditors, that they must provide full information. Why? Because it would not make any legal and principle sense if you were to give somebody a loan and then later disclose the terms once there is default. Let's say additional penalties. You've seen circumstances where somebody takes a loan, and then at the beginning when you're taking the loan, you are not told that the penalty will be tripled thrice, or the penalty will be of this percentage in case of default. At the point of default, somebody wakes up and tells you, look, you have defaulted, you will now pay me twice the amount. So those are disclosure issues that are provided for. If you look at Section 13 of the Consumer Protection Act, one of the ways in which consumers are protected is that disclosure of information ought to be reasonable and in good time, in a manner that enables the person taking the loan to be able to know all that comes with the loan. Now, if you flip it on the other side, the person to whom the loan has been given, must always ensure that he abides by the terms of the loans and the penalties, and that it is always good to reasonably give notification to the person to whom you have taken the loan whenever there is potential of default, because the Kenyan system is also running away from everything going to court. So are you able to negotiate, before when there is an impending default? And those are issues that are provided for in the law. So the protection in such a way that the debtor is not vilified and stripped off of their dignity because there's a debtor, and the creditor does not take advantage, and is not taken advantage of just because the law protects much of the debtor. So that's the flip side. Yeah.
Let's talk about now defaulting, now that you're talking about it. Isn't there a grace period, for somebody who has defaulted on a loan, let's say, for someone to come and now negotiate how they want to repay this loan in their own terms? Doesn't that exist in the law?
You see, Anne, all loans are contracts. They are contractual relationships in nature. And because they are contractual relationships in nature, the only intervention the law will make into a contract is that contract is unreasonable. So this is the point. The point is that if you default, depending on the contract that you're having, there are other contracts that, for instance, provide that, you're supposed to be given notice of 30 days upon default, that recovery will take place, or that penalties will accrue, or that certain actions will be taken within the confines of the law. Now, under such circumstances, it would be unreasonable for the creditor to then, go against those timelines and use even shorter timelines. There are times you have signed a contract and it's 30 days notice. Then you being given 3 days, or intimidation, normally you get a text. You're being told, a text is being dropped and you're being told, if you don't pay this debt within 3 days, then you will be arrested, or then something will happen to you. I mean, there are even people who have been threatened with death, on this issue of debt collection. So the point is, because this is contractual in nature, the timelines specified within that contract of the loan must be followed. And that grace period is there because of the idea of the right to fair hearing. We do not dispute that somebody has defaulted or has a loan, but it is always important to give them fair hearing. And giving them fair hearing means give them reasonable time for them to either offer an explanation or you negotiate a favorable term or vary the initial term. So the right to fair hearing goes fundamentally into the idea that the time should be reasonable and not short, too short to allow somebody organize themselves.
Yeah. Now, there's always this conversation that, in matters where contracts are involved, in-house discussion is very much advised. Just to talk about between the two of us, say we have a contract together and I've defaulted, In a case where we have talked about it, I've said that I cannot pay it in this particular time, I'm asking for more time, but this creditor, wants to proceed and take me to court and auction my property, take 1 to 3 of my belongings, then am I protected by the law at that point, or is it standard that there is a contract and there's nothing much that can be done?
Absolutely, you're protected. You see, what happens, Anne, is that the law is not a straitjacket. And the law is not a straitjacket when it comes to loans. What I simply mean is that there is no one standard procedure that any contract or loan or default will often take. What then happens, Anne, is this. There is no doubt that a creditor may want to take you to court. Even upon negotiations. If you don't agree, the inevitable is that a court process will ensue. But a court process does not just ensue. There is a very clear process. If somebody has your loan and he has defaulted, the very first thing you do is to write for them a demand letter. And the demand letter should be able to specify for them the terms of the loan, the outstanding debt, balance that is left, and then be able to inform them that suppose they don't pay within a particular timeline, whether it's 14 or 21 days, then legal actions will be taken, to their detriment. Now, it is upon that notification, even when there are ongoing discussions, it is that notification that then kickstarts the legal process. Now, there are 2 outcomes. It's either they will act on the demand letter and pay the outstanding balance, or they will actually try to get into negotiations with you, But if they are not able to pay, you eventually now approach court. But you cannot approach court before you actually take out a demand letter. Or if the terms of the loan is such that it prescribes alternative dispute resolution mechanisms, you cannot approach court directly. It's called the doctrine of exhaustion of remedies. You have to exhaust the available remedies that are within that contract before you eventually go to court. It is only after that you go to court, and that period is important to allow somebody to organize themselves. When you eventually now go to court, and then the court will hear the matter and determine whether really the debt is outstanding. Once the court makes that decision, you also can't just come out of court with a judgment of court and go and auction somebody's property. You have to then obtain a decree, from that decision, and then serve the decree. And tell these people, that as per this decree of the court which was given in our favor, you are supposed to pay within this period. Now, if that period upon which the court has given them to pay lapses before they pay, that is when you go to the process called execution. And execution is so many forms. You can send auctioneers, It can be attachment of assets. If it's a bank process, it can be what is called garnishee proceedings, where you realize somebody has some money in some bank account. You want to attach that and ensure that money is used to repay the debt. So that's basically the process. So it's not a wake-up thing, even if you go to court and get a judgment and then the next day you just move with the judgment and auction somebody's property. No, you have to obtain a decree that says, in my favor. A decree is a document that just says, in my favor, this decision was made in my favor and I'm supposed to obtain this amount of money from you. Then you are given time again, despite having been given time when the demand letter was given.
Yeah.
Being given time again to act on the decree. If you don't, execution kicks in.
Now let's ground this. When a debtor calls or just visits your place, as you know, what do you need to do from the onset? When a creditor now calls or visits your place, they say they want to come now and take matters in their own hands now. What should you do as a debtor?
First, I must recognize that I think it has become so common, unfortunately so, within the Kenyan legal framework, or just within the Kenyan, even business environment, that the most common mechanisms I've seen people use and deploy is using police officers, to invade your property. I've had instances over social media where somebody says, I run a laptop business, police officers came in, they confiscated things, and moved down with things, they destroyed property. That is the most common. But this is the point. If a debtor storms into your place on their own accord, because they can actually come on their own or use, agents, an auctioneer. Now, let me deal with when it is an auctioneer, then I'll come with when it's themselves now.
Yes.
If it's an auctioneer, the auctioneer must follow due process. And in this country, there is an Auctioneers Act. And there are regulations that guide auctioneers. Auctioneers, number one, must identify themselves. Auctioneers must be able to come with a decree. They must come with a decree. Evidence that they have lawful authority, that they have been given by the creditor to come and recover that debt. You cannot do debt recovery through an orthodox means, where you just wake up, use police officers or use bouncers or use strange people, or use, just a gang. It's even done within the criminal enterprise to threaten somebody to give out debt. So they must identify themselves. They must have lawful authority of the creditor. There must be an authority that tells them that we have come to, they must show you an authority that tells them we have come to auction you or we have come to seize your property. That is important, even when a judgment has been given against you or you are aware you have a debt. That is very important, because without lawful authority, they can't take the laptops, they can't take the property without the lawful authority that has come from the creditor and lawful authority that has come from court. That is important. Now, when they come by themselves, debtors have no authority to enforce collection of debt outside the law. They have no authority. You see, and if I have your debt and I want it, I can't come by force. I have no authority to do that. Yeah, because then it will be me who gave the debt, me who knows you have my debt, and me who is being the executor. And that is why the legal process comes in. Even you, somebody has 3,200,000, 300,000, without lawful authority, if you don't obtain a decree, if you don't come through the legal process, you can't directly come and seize somebody's property and sell. Because then what that will amount to is illegal collection of debt. And damages will be awarded.
So what are some of the illegal tactics, now that you talk about illegal ways of getting back these debts, that these collectors use, that Kenyans might not really realize that this is illegal and they should actually seek the help of a lawyer or just the courts?
I think, Anne, the rule of the thumb is you are not supposed to be arrested for a civil debt unless the court has made a decision that you be arrested. You see, the criminal justice system is supposed to serve and deal with criminal matters. But what we've seen in this country, Anne, is a scenario where police officers are being used to settle matters that would ordinarily go through the civil process, within the court process. And this is how they do it. You know, some are even coined as charges, you know, obtaining money by false pretense. But when you look at it, it is a civil commercial dispute, a normal contractual commercial dispute. So one of the mechanisms is intimidation and coercion, which they normally do through police officers. Another, which has become very common with digital money lenders, is incessant calls, sending text messages to all your contacts, you know, being put a guarantor without you knowing, and now every day you receive messages from these people, even if you are not the one who actually took the debt. Incessant calls, text messages, intimidation, coercion, blackmail, or even going online. I've even seen, you know, individuals taking bloggers and giving them money, and, you know, they call it expose, you know, and they put contacts of people out there. They begin saying, you have this debt, you were supposed to pay, you have not paid. By the way, Anne, it is important for Kenyans to note that the High Court of Kenya and even the magistracy has located the dignity accorded to a debtor under Article 28. There are two main rights that are protected of a debtor. The right to inherent human dignity under Article 28 as a human being, which then prohibits actions that I've talked about. Actions like disclosing you know, the debtor's status online, disclosing their contacts, the right to data privacy, and generally privacy under Article 31 of the Constitution. So those are the dirty tactics that people have commonly used, or debtors have commonly used, to collect debt outside outside the legal system. And when you approach the High Court, either through a constitutional petition or the Office of the Data Protection Commissioner, you know, by a complaint on your data violation, the damages will be grave on their part.
Now, with that said and done, Wakili, what is the thin line between, you know, legal debt recovery and extortion? How do you know that, you know, this is the legal way, and now when it comes to this, now this is extortion?
Exactly. Extortion is now when you come up with unreasonable terms. Because, you know, what extortion is supposed to do, extortion is supposed to coerce. You know, you have agreed, for instance, that if you default on this debt, you will pay 15%. 15% of the sum of the total. Somebody wakes up and say, in fact, if you don't pay it by tomorrow, it will be twice the amount. That is now extortion. Because they are trying to coerce you, they're trying to put you in a corner, such that thinking of the high value that has been put to you, then you will be driven to look for the money and pay it. And that is where you actually find that's where you actually find extortion coming in.
All right, so how can, just switch it off. How can someone verify whether a debt collection agency is legitimate, Wakili?
Very, very important, because the Central Bank of Kenya has come up with regulations. All digital money lenders are regularized by the Central Bank of Kenya. They are licensed by the Central Bank of Kenya. So the Central Bank of Kenya is the legitimate. It's the legitimate authority that confirms those who have been licensed and those who have been given the mandate to give credit through the digital means. So it's the only way, it's the only mechanism through the CBK, because they have regulations and they are the people who license.
So if one is not able to present this document from the Central Bank of Kenya, somebody should not feel moved in any way by these debt collectors or auctioneers? Not
even disturbed for a moment. You're not supposed to be disturbed for a moment. If somebody does not show proof that they are licensed by the CBK, the Central Bank of Kenya, then, you know, in fact, the other day I saw the Small Claims Court. The Small Claims Court even gave a very interesting decision that they will not hear any question on digital money lenders if that money lender is not licensed and regularized by the Central Bank of Kenya.
Still on that topic of small claims court, you know, it has been designed to streamline civil recovery of debts, Evans. And has its introduction helped, you know, just reduce abusive practices by offering an, you know, official avenue for debt recovery, or there's still gaps that exist in this small claims court?
I think there are, and I think a number of gaps exist in the small claims court. I think perhaps the biggest challenge with the small claims court right now has been backlog. Yes. You'll find a cost list where there are cases for the small claims court, and number 1 to number 900 is digital money lenders. You know, and same digital money lenders every day, every time. They clog the small claims court. And I think one thing that the small claims court also need to remind itself is that ADR does exist. There are so many matters that merely can be sorted out by a small discussion, but they are being taken all the way to the small claims court. The small claims court was not meant for backlog. The small claims court was actually meant for expeditious and reasonable resolution of the disputes, you know, especially regarding debt collections, the small matters that can be handled down here. But what we've seen is that it has been flogged by all manner of claims. And part of that problem is the court has not really been able to define the scope of its jurisdiction, like what are the matters that it is supposed to handle. Because there are several circumstances where the High Court has reversed a number of decisions of the small claims court because they have gone beyond what they should actually be handling, which is in the scope of all the other courts. So I think we can actually improve the small claims court by first ensuring, and all the adjudicators who serve in the small claims court should be able to find out that all the digital money lenders that bring backlog of cases every day are, number 1, licensed, and that number 2, if some of those matters can be channeled all the way through alternative dispute resolution, then that should be done in the earliest of opportunity.
You talked about timelines when we were just starting with this conversation, but what exactly is the timeline within which a debt should be collected?
It's an interesting question, because, you know, the different money lenders, for instance, Tala, they have different timelines. Although what I've seen is that the standard timeline has always been 60 days after, 30 to 60 days after default. So that flexibility squarely depends on the contract.
So if somebody comes to you, you know, 5 days into taking a loan, that's harassment?
No, that would be harassment. And in fact, I dare say, if there would be a contract that gives 5 days repayment, that contract would easily be found unreasonable. You know, what the court will actually find out is there is no template for timelines. What the court will actually find out is whether that timeline is reasonable. Did it accord the debtor an opportunity to reorganize themselves, to respond, or even to do repayment? Because if it's too unreasonable, surely if you give 3 days, if you give 5 days, even a court of law giving a decree would not give 3-5 days for repayment. It's normally between 30 to 60 days. Yeah, so that's basically the average timeline. But then different contracts, you know, are modified differently. And I've always said the courts will not intervene in the contractual obligations of parties unless such obligations are in such a way, or such terms are in such a way that they are fundamentally erroneous, or they are fundamentally, you know, go against certain tenets of natural justice like fair hearing, reasonability, and irrationality, and other such principles.
Yeah. Now, Wakili, you know, I was looking up this topic, and I realized that the US and South Africa, they have a debt collection licensing authority. Do you think that would come in handy for Kenyans, and what ethical standards are required in order to achieve that level, you know, of discipline?
As of it, as it is now, I think we're in dire need of that. We're in dire need of that because in this country, you can easily be taken to CRB, even without your knowledge. I've seen people going to court because a debt that, an interesting case scenario, for instance, I've seen cases where somebody buys a Safaricom line. You begin, now Safaricom likes reassigning lines. You buy a Safaricom line today. That Safaricom line had been used by somebody in the year 2019 or 2018. They took a debt. By the time you were coming to the possession of the line, you're not aware that there was a debt, or that the debt was even repaid, or it was outstanding. You will find yourself in a CRB when you are actually applying for a loan from a bank or from a SACCO. So I think we need that debt licensing authority like other countries, South Africa, the US, and even Philippines. You know, there are more nations with such structure. But I also think that the CBK, the Central Bank of Kenya, should still be the sole licensing authority for digital creditors. Because part of that mechanism is going to be effective due to data protection issues. Because one of the CBK regulations is that you're not supposed to share data. You're not supposed to have access to the borrower's contact list and begin sending people messages. You know, in fact, the court in 2024 decided that follow-up on defaulters through guarantors, those who you put their numbers there to be guarantors. The credit provider has an obligation to confirm that all those whose contacts have been given as guarantors actually gave consent. It is no reason to say that the borrower gave me the contacts of these 3 people to be as guarantors, and therefore I'll make incessant calls, I'll send messages morning to evening, daily, on daily basis to them. The court actually found that it was unreasonable. The incessant calls that people are always given all the time and the messages that they are always, sent to all the times are actually unreasonable to the extent that they should not go beyond merely finding out where the defaulter is. You know, it almost makes the guarantor to be the principal, to carry the shoulder the principal liability, or to be like the one who took the loan. So I think the CBK should be maintained as the one who does licensing for digital credit lenders, because they have also become a prey for data protection, issues where you find you took a loan with one digital credit provider, you find the other credit provider is sending you an invite whether you should take their loan. You know, that means in one way or the other your data actually leaked or your data was accessed by a different entity. So they are bound by data protection principles under the Data Protection Act, Section 25. All those principles that are there, Section 31, they are bound by those principles. They are bound by Article 31 on data privacy. They are bound by the principle and the right to human dignity under Article 31 of the Constitution. So yeah, we need that authority, but at the same time, we do need the CBK to continue dealing with the digital credit providers, because I do not think that authority will be able to provide for both the debts that are collected outside the digital means and those that are collected within the digital means.
And you know, it turns out that Kenyans are very much afraid of debt collectors more than they are afraid of those debts themselves. So perhaps would you say that it's because of these data breaches that these digital lenders are, wanafanya inaendelea, when you take a loan with them, the constant harassment, the threats, they even talk about courts, there's something they say. Would you say this is why Kenyans fear debt collection more than even taking the money itself?
No, I think Kenyans fear debt collections largely because in this country we do not have a culture for the rule of law. Because we don't have a culture for the rule of law, police officers will come and harass you and take your property, and there's nothing you'll do about it. You see? So perhaps, I think, for me, the more reason why Kenyans are afraid of debt collectors than the debt itself, is because of the means in which this has been done. Some have been done through brutal force. Some have been done through turning the criminal justice system to settle civil scores, matters that can actually be handled with, through a court process. You even seen commercial agreements being turned into criminal matters. Well, that is part of the reason why Kenyans could be afraid, because of the external mechanisms, the informal mechanisms that have been actually used to do debt recovery. Yeah.
So would you say that Kenya's consumer debt crisis is also as a result of low financial literacy, and should debt collection, go hand in hand with the public education on borrowing and repayment reforms?
Exactly, and this is the problem with the digital credit providers. You see, most Kenyans, even those that have no formal literacy, have smartphones.
Yes.
And therefore they are able to access the processes and be able to take loans. But they sign the terms blindly. They do not, most of the time, we do not read. You know, not read what actually you're signing. You know, most of the things they just sign. Kenyans just sign things online. Even when you buy a phone every day, and if you ask Kenyans how many times they read those flippers that are always put within there, those small karatasis, they don't read them. You don't read the terms. You don't read even warranty terms. If you buy an electronic or if you buy a TV set, you don't read. So that has also gone to the digital credit providers, because most of the time the terms are there. Most people who take up the loan, they just sign blindly, and then at the end of the day, they actually realize, wow, it was something different that I got into, you know. So I think digital credit providers should go beyond just giving loans. They should actually also provide those who are taking the loans with the entire information, recourse, whenever there is a default, process that will be used whenever because then in that manner, it will be easy for the person giving the loan or the digital credit provider, I mean, for the person taking the loan, to then decide whether they're taking the loan or not. Yes.
Now that you're talking about also, you know, the breach of data by these digital lenders, so should an employer be allowed or to deduct salary for, you know, personal debts in case where this, you know, lender comes to the employer, now they want to contact you, personal contact your brother, your mother, your neighbor? Is the employer really allowed to deduct part of your salary to pay off these debts?
Exactly, no. You know, personal debts is not like housing fund. You know, it's not like NSSF. You know, the point is this. It would be very unreasonable for your employer to blindly, not being party to that contract. You see, third parties are not bound by a contract which they are not part of, unless there are exceptional circumstances. You will not be bound. I mean, when you are taking the loan with Tala or other different digital creditor, well, the employer was not there. So that is an external. The only circumstance I think where the employer could come in is if, for instance, you use your salary slip, you know, to get a loan from these entities.
Yes.
That is the only point that your employer is allowed to come in, because your employer is actually in charge of your slip. You know, employer is in charge of your slip. But for personal debts, where now your employer was not party to, it would be very unreasonable. Yes.
And in cases of, you see, joint loans, say married couples, and then they separate. Now, who gets pursued in terms of, you know, just trying to get back this loan that was taken when these two are couple?
That is an interesting one, because that gets into the idea of matrimonial property. You know, matrimonial property is normally comes on board once you have shouldered the liabilities and now the assets are being distributed. But I think liabilities too are co-shared. Liabilities too are co-shared. I don't think any digital creditor or any loan lending entity would just decide to go after one couple. That would not make any logical sense.
What if the name there was of just one person and not the couple per se, just one?
No, it would be very difficult. It would be very difficult. You see, what happens, unless the loan entity is one that if you are to take a loan, you need a spousal consent. You see, just like buying land and such other matters. But if it was just one person who took a loan on their own accord, they will be pursued individually. Yes.
So what is the role of, you know, you talked much about the CBK, and I want you to explain to us the role of, you know, the CBK in debt recovery, just in depth, so that we can know really when the CBK should come on board in terms of just recovering that debt.
You see, the Central Bank of Kenya came up with regulations. There was an amendment to the Central Bank of Kenya's Act in 2021. Then they came up with the regulations, I think 2022 regulations. Why was the regulations necessary? The regulations was necessary to ensure that the objectives of the Act, where debt recovery, debt collection, and you know, giving loans is by digital credit lenders and all other lenders, is given in such a manner that respect human dignity. So what they basically do is that all those who want to be digital credit providers apply to the CBK. And the CBK is able to give them license that duly gives them mandate to then provide loans to the general public. But at the same time, the CBK regulations have come with some stringent principles, like you cannot use intimidation. Because, you know, the CBK realized that most digital credit providers are harassing Kenyans, are intimidating Kenyans, are using blackmail, extortion to take up their loans. So they came up with regulations and thought it wise that, well, it is important that all these people who take loans are dignified, and that one, they take loans from entities that do exist. Because before the regulations, what would happen? Because what happens when a digital credit provider gives you a loan, then the next day, once they extort you and you repay the loan twice or thrice, they are not there. You can't take them to court because they're not licensed. You do not know them. There's an entity that is unknown, completely unknown in law. But you see, when they are licensed and when they are registered, duly registered, then it becomes easier to pursue them because it is an entity that is within government reach. Therefore, taking them to court becomes very easy. So the CBK was just reinforcing what we already know in the Consumer Protection Act and what the CBK Act brings on board, that the process of debt collections, whether it is digital or whether it is in the normal process, should be done in a way that does not harass, does not intimidate, does not extort. So that those regulations prohibit certain actions. Part of that action is access to the borrower fund data. Number two, it is ensuring that those who are listed as guarantors are protected. Their consent is required. The digital credit provider must satisfy themselves that these people gave consent to be guarantors, because it will not be a reason for them to later then argue that we were only given this data by the borrower. We did not know whether they actually obtained consent or not. No. The law requires them to ensure that those whose numbers are being given, whose data is being given, are protected within the law, that they have given their consent and that they can be pursued or they can be followed up. Now that is how the CBK comes in. The CBK comes in to protect the data space within digital credit lending, and also to protect actions like intimidation, coercion, extortion that are extremely external to any contract. Any contract cannot be, and it's a basic principle. You cannot enforce any contract by coercion or intimidation or blackmail, because those actions vitiate that contract. Damages will be given. Yes.
Perfect. I just want to remind our viewer that there is a number on their screen that they can call in any time, of course, to ask you questions, Wakili, and I'm told they're afraid. Wakipiga simu wanasikia mtu uko nyuma, and then they get scared, they hang up. Don't be scared. That's our director, and he'll sure hand in the call for us here in studio. But there is a question here for you, Wakili. Ruth Wanjiru anauliza, are debt collectors allowed to demand payment in cash or in non-official channels like M-Pesa to their personal lines?
Absolutely, the answer is no. Whereas money can be paid in cash, there must be evidence of receipt. I mean, evidence of payment in terms of receipt. That is important. Number two, once an agency has come on board as a debt collection agency duly licensed, they have a mechanism of where they direct you to make the payment. It cannot be personal lines because they are not acting on personal basis. You see, debt collecting agencies are collecting debts on behalf of somebody else. Okay? So it cannot be that they are taking that money to their personal lines or personal accounts, external of the formal engagements you had. You know, most engagements have a way in which you are to repay the debt. You're told, deposit the money in this account. You know, that is your term of engagement. There's nothing wrong with M-Pesa because there is a money trail that can actually be found as evidence of payment. Statements can be generated, so there's absolutely no problem. But it should not to be their own personal gain, because I've seen that happening, where those who are coming to collect the debt, they collect the debts to themselves. Then later on you are told that you did not actually do the payment.
Let's get this call from Paul Kamau. Paul is calling us from Kayole. Paul, good morning.
Good morning.
Talk to us.
Thank you much. Thank you very much for having Wakili on the studio. My question is about, there was a time, like, I'm not going to name the organization that has given the loan, but there was a waiver from the government.
Okay.
Especially when the current president came in. Then the message came that the loan, you're supposed to pay the waiver and the amount is going to be cleared. Just for later on, the organization started to use other groups to ask for the same money which the government has waived away.
We are losing you, Paul. We are losing you.
I'm saying?
Yes.
Later on, after the government has said they had cleared the amount out of the waiver period, some other groups started calling, claiming the amount to a point that the balance started reflecting on when they were sending the messages. So how is the waiver amount, which was claimed to have been cleared by the government, how is one supposed to follow up? Putting in mind the organization which had given the amount and the waiver is a big one. Yeah, how is one supposed to follow up?
All right, thank you so much, Paul, for that question. Wakili, he's talking about a waiver. Government gives them a waiver. The banks, comes in. Now, how does the waiver just come into play in such a case?
Now, that is an interesting question, because most waivers from the government operate, the waivers always have terms of that waiver. Every waiver has its own terms. If it is waiver on individuals, that waiver, the government must actually come out. Most waivers are normally gazetted by the cabinet secretaries in charge of different, parts, or whether it's the KRA. The KRA gives waiver every time. They will, or even tax amnesty. They'll give you notification that it has been waived, the amount that has been waived, and what you're left to pay. So most waivers are in particular terms. So what is important for Kamau to actually find out is what were the terms of that waiver. Was it to take care of the full amount? Was it to take care of the partial amount? Was it a particular percentage? And if that question is answered, then the next question is, was it actually actualized? Either in terms of gazettement, either in terms of an order. What is the evidence that the waiver had actually been given? Because the only way the bank can come in and all these other entities that were in the debt he is talking about is if either that waiver was given but was not actualized. Because a waiver must actually be either gazettement or written notice. There must be evidence that a waiver has been given. A waiver cannot be given by word of mouth. It can't be given by a promise. There must be evidence, either documentation, either gazettement, or to those that the waiver applies must be given the terms.
We still have Eric also on the line. Eric is from Eldred. I don't know if you've answered the question by Paul, or if you can come back to it.
Yes, I can actually come back to it, but the point I'm making is waivers have terms.
All right, let's get this one from Eric, and then we'll come back to that one from Paul. Eric, good morning.
Good morning.
Talk to us.
Okay, nilikuwa nauliza Wakili, kuna hizi station inasema inapeana loan, but
we can't hear you, Eric. All right, Eric tumempoteza. Let's come back to this one here, Paul. You were explaining to him about how this waiver cannot just be about word of mouth.
Correct.
But signed?
And evidence that it was actually actualized. You see, when KRA gives waivers, we've seen that. Or tax amnesty, the particular people to whom waiver is given are actually notified in the terms of that waiver, whether the partial amount or whether it was on full amount. So that is important, because the only way the banks and all these other entities on what Kamau was talking about can come in is either if there was a promise to give the waiver but it was not actualized, or that the waiver was given but it did not apply to Kamau, you know, because any person who has been given a waiver must be notified. Yes.
Another question is here: does declaring bankruptcy protect me from debt collectors?
Absolutely no. Because I would not actually say that merely by just saying you are bankrupt. Because bankruptcy is a threshold in commercial matters. In commercial law, there is a threshold that has to be met for you to be declared bankrupt. You see? So if that threshold is met, and it's a very high threshold, you know, in order to be met, part of the things that have to be actually confirmed is whether you have no known property. No known property. It's not that you have property and you have hidden. You have no known property. So it's very difficult to meet the threshold of bankruptcy, especially with the digital credit loans that people take. It's very difficult. And the process alone of just going to court and ensuring that you are declared bankrupt, because you can't declare yourself bankrupt, and the court has to declare you bankrupt, and a bankruptcy order must be given. That is the only time you are protected from the debtors, you know. But bankruptcy has a very high threshold that cannot be by word of mouth. You can't just tell a debt collector that you are bankrupt. A court must declare you bankrupt after due process has been made, and that is the only way you are protected.
All right.
And not through concealment of some property.
You're telling me about there isn't any legal definition of a debt collector before even we started this conversation. And, you know, given that Kenya does not have a specific law defining or licensing debt collectors, so what legal risks does this, you know, regulatory vacuum pose to both debt collectors and creditors?
That's a challenge. It's a big challenge, because, as I said, the legal framework on debts, debt collection, or even loans is very fragmented. Fragmented because the SACCOS Act has their own framework, the Auctioneers Act their own framework, the Consumer Protection Act, you know, on this side protects consumers. Well, the CBK regulations are also here with us. So I think the only definition that is there is who is a digital credit lender, you know, provider. We do not have a centralized definition of a debt collector, and that is risky. And I think it has been able to allow, at least for digital credit providers, we now know that when they send a debt collector, we know whether they are licensed or not, and also whether that debt collector is an auctioneer that is registered and licensed or not. But for others that are external, like debts, if I give you a debt today, you wouldn't know that I've sent a debt collector or one is a licensed debt collector unless they are an auctioneer which is registered.
Okay.
So that's a challenge.
Let's get this call from Joseph as we close. Joseph, good morning.
Morning, man. How are you?
Good, good. Talk to us.
Just a quick one. Can I proceed or I wait?
Yes, yes. We can hear you and you're waiting for your question.
I wait, huh?
Joseph, you can ask your question.
Let me ask, huh? You've defaulted, huh?
Okay.
And someone takes you to the CRB. Is he supposed now to come back and demand the loan again for you to pay?
Perfect.
That's my first question. The other one, for the digital lenders, is it legal for them to even threaten the calendars and send them messages, threatening messages? Is it right for them to do that? They send threatening messages, they tell them that they'll come for them, they threaten the calendars. Is it legal? Want the lawyer to advise us.
All right. Thank you so much, Joseph, for your call. Wakil already addressed that one for digital lenders.
Yes, but I need to make one more emphasis even as we close.
Okay.
The Penal Code Section 238, you know, criminalizes such threats. Any level of threat, blackmail, intimidation is a criminal offense that can actually be dealt with in the criminal justice system. So it is not only unethical, but it's a criminal offense to actually threaten. Now, for sending messages and calls, I have said there has been a decision that has outlawed that, and that has said that is against right to human dignity and also data privacy. So that is wrong. Now, once being taken to CRB does not take away the loan, and if it does not even take away the idea that the loan needs to be demanded. So one can still recover their own. Just that once the loan has been satisfied, you need to be taken out of CRB. You can't be in CRB and you have satisfied the loan. So once you are in CRB, that does not take away the obligation of the creditor to demand his loan. He can still demand the loan. But then the end game is that once he has paid, you pay that loan, you're not supposed to remain in CRB. Those who have remained in CRB despite having paid their loans have gone to court and have gotten damages.
All right, thank you so much, Joseph, and everybody who's been part of this conversation. Thank you so much for calling. I know we've had Eric, Paul, and Joseph, of course, and thank you so much, Wakili, for making time to take us through the rights of a debt collector and a creditor, what you need to know, what's legal and what's not. That brings us to the end of this conversation and to the end of Morning Cafe. Thank you for watching. Good morning. Hi. Enjoy the rest of your day. Have a good day.